Well, good morning, everyone. Welcome to Cornerstone Barristers webinar entitled, What Did the Supreme Court Decide in Croydon London Borough Council versus Kalonga? I'm Kelvin Rutledge. I'll be presenting this webinar alongside Riccardo Calzavara, and together we represented Croydon Council in the Kalonga case. Also amongst the delegates this morning is Jenny Fraser-Brown from Croydon, who instructed us in the matter and who gave support throughout the litigation. After this introduction, I'll hand over to Riccardo, who would explain how the Supreme Court dealt with ground one of the appeal, which concerned the correct reading of Section 82 of the Housing Act 1985, the section which deals with security of tenure. And following that, I shall say something about ground two of the appeal, which raised the question of whether anything in Croydon's standard form of secure tenancy constituted a forfeiture clause. Many local authorities will doubtless be looking at their own standard terms and comparing them with Croydon's in this respect. Finally, we will answer as many of the excellent questions that we've received from delegates as time permits. Now, local authorities and other social landlords have had the ability to grant fixed-term secure tenancies for over 40 years, and yet Kalonga was the first case to reach the Court of Appeal, let alone the Supreme Court, specifically on the question of how the landlord may bring such a tenancy to an end prior to its contractual expiry date. And the reason for this is that until flexible tenancies were granted by Part 7 of the Localism Act 2011, few social landlords bothered with fixed-term tenancies, preferring instead the periodic model. But flexible tenancies soon took off, and some authorities granted them in their hundreds, and in some cases, thousands. Whereas the Localism Act made provision whereby the landlord could, by a process of statutory notices, recover vacant possession from the tenant upon the expiry of the fixed term, the legislation was silent on the ability of the landlord to recover possession during the fixed term. Now, there are a number of reasons why the landlord would wish to achieve this. The tenant may have broken the terms of their tenancy. The tenant's circumstances may have changed, such they are overcrowded or under-occupying their property, or the landlord may wish to redevelop the property. The Court of Appeal in Kalonga had held that unless the fixed-term tenancy contains a forfeiture clause and that the landlord has grounds for exercising it, the landlord is locked into the agreement for the full contractual term, whatever the conduct of the tenant, or otherwise the need for early possession. Indeed, even if the tenancy contained a forfeiture clause, it was, on the Court of Appeal's analysis, ineffective in respect of those statutory grounds which are not fault-based, such as redevelopment or under-occupation. The problems this interpretation of the legislation created for those landlords whose tenancies didn't contain a forfeiture clause was compounded by three further factors. First, the Court of Appeal in UKAC and the London Borough of Islington had held that a landlord may only recover possession from a secure tenant on one or more of the statutory grounds for possession. It could not, for example, seek common law rescission of the tenancy on the grounds of fraud. In terms of its ability to recover possession, therefore, everything turns on the landlord's ability to access those statutory grounds, and the Court of Appeal's approach severely restricted such access. Secondly, the effect of the variation of tenancy provisions contained in sections 102 and 103 of the Housing Act 1985 is that the landlord under a fixed-term secure tenancy cannot unilaterally vary its terms, except with regard to rent, for example, by writing in a forfeiture clause. Therefore, a fixed-term secure tenancy which is granted without a forfeiture clause cannot subsequently become forfeitable without the tenant's consent. Thirdly, Section 119 of the Housing and Planning Act 2016, which was passed specifically to address this problem, to enable landlords to end fixed-term tenancies before they expire, has not been brought into force and probably never will be. So let's look briefly at the legal and factual context of the Kalonga appeal, and move please to slide number 1. Now this is section 82 of the Housing Act 1985 as currently enacted. And we see it's a section in 4 parts. Subsection 1 provides that a secure tenancy, which is either A, a weekly or other periodic tenancy, or B, a tenancy for a term certain, but subject to termination by the landlord, cannot be brought to an end by the landlord except as mentioned in subsection 1, capital A. Pausing there, this is a key provision and the only provision by which social tenants are provided with security of tenure. So subsection 1 deals with 2 types of tenancy, a weekly or other periodic tenancy, and a tenancy for a fixed term, but importantly, a fixed term which is subject to termination by the landlord. And those words were critical to the court's analysis of this question. And then capital 1A, which gives the appearance of an amendment, a later insertion, is historically owes much to the original version of this in the 1980 Housing Act. And it provides that the tenancy may be brought to an end by a landlord, and then lists 3 ways. The first is by obtaining a possession order on the statutory grounds. The second is by obtaining an order under subsection 3, we'll look at that in a moment. And the third is by obtaining a demotion order, which was a later innovation. And then subsection 3 says that where a secure tenancy is a tenancy for a term certain, but with a provision for re-entry or forfeiture, the court shall not order possession of the dwelling house in pursuant of that provision. But in a case where the court would have made such an order, it shall instead make an order terminating the tenancy on a date specified in the order. And section 86, periodic tenancy arising on termination of fixed term, shall apply. And then subsection 4 is to be read with that, and that reads into the section 146 of the Law of Property Act and the law concerning relief from forfeiture. So the second question in the ground one was 2 limbs. The first limb is what is the meaning of the expression subject to termination by the landlord. The second limb is if the tenancy is a tenancy for a term certain subject to termination by the landlord, how can the landlord terminate it? Is the landlord entitled to choose from the menu provided in subsection 1, capital A to C, or is it, as the Court of Appeal held, obliged to go via the termination route in subsection 1, capital A, B? And what we've done in the next slide, thanks Riccardo, the next slide, is we've stripped it down to the bare essentials so far as the Kalonga case is concerned. These are the essential words: a secure tenancy, which is a tenancy for a term certain, but subject to termination by the landlord, cannot be brought to an end by the landlord, except, and then the 3 ways that we've listed. Next slide, please. So the issues before the Supreme Court were threefold. Firstly, what did the word subject to termination by the landlord mean? As Riccardo will explain, the judge at first instance in the High Court held that those words mean termination by forfeiture alone. So a fixed term tenancy which had no forfeiture clause didn't come within section 82. That creates its own problems, as Riccardo will explain. The Court of Appeal accepted Croydon's case that the word subject to termination by the landlord means termination by any means available to the landlord as a matter of contract. The Supreme Court felt that that was probably the major issue in the case, as Riccardo will explain. The second issue for the court is how can the authority recover possession of property let under a fixed term tenancy during the term? This is the question of whether the termination route is the exclusive means by which the landlord under a fixed term secure tenancy can proceed, or whether any other item on the menu is available. And the third question, which was raised by Ms. Kalonga's initial application for a preliminary issue, was, did Croydon's tenancy contain a forfeiture clause? And if we go to the next slide, we've extracted here the critical provisions of the Croydon standard tenancy condition that applied in this case and applied in hundreds of other cases. And some of these clauses may be familiar to delegates. We've certainly seen similar ones in other tenancies. But these were the ones that the courts look at. Both the judge at first instance and the Court of Appeal found that none of these terms constituted in law a forfeiture clause. The Supreme Court disagreed and found that they all applied. And I'll come back to this when I speak on ground 2, but we put in bold perhaps the most critical term, which is that Croydon Council reserve the right to take eviction action at any time if one or more of the grounds for possession set out in Schedule 2 to these conditions apply. Now, I'm sure that delegates are familiar with the statutory grounds, so important they are that the Supreme Court appends them to its judgment. The judgment, if you don't have a copy, is available on the Supreme Court website and also I think on Bailey and Westlaw and other providers. But the statutory grounds are 15 in number, 16 if you include one specifically relating to Wales. And in very broad terms, they are fault-based grounds, such as non-payment of rent or breach of other obligation of the tenancy, antisocial behaviour, tenancy by misrepresentation, damage, waste, all those things. We're all very familiar with those. But there are also non-fault-based grounds, such as redevelopment, and such as those grounds 12 onwards, which concern strategic reasons why the local authority or the landlord may wish to recover possession, even though the tenant is not at fault. So those were the issues before the Supreme Court. That was the legal and factual context. So what we're going to do now is to move into the substance of the Supreme Court's determination of ground 1 of the appeal, the correct reading of section 82. And for that, I'll hand over to Riccardo.
Good morning. As Kelvin has said, I'm looking at ground 1, which was in 2 parts. This was supposed to be a straightforward claim for possession, relying on the tenant's breach of tenancy. When the claim was brought, there were substantial rent arrears and there was a long list of long-standing alleged antisocial behaviour. But the claim was defended on the basis that the only way to determine a flexible tenancy during its term was by a section 82 subsection 3 termination order, which is the forfeiture type route. Kelvin's outlined it and it's on the slide that you should all be able to see. Forfeiture type route because it provides for termination during the term for fault, but not forfeiture. It's a different remedy. In its reply, the council said it didn't rely on forfeiture. And that's how we got into a situation in which it was necessary for the court to construe the meaning of the statute, and particularly of section 82(1) subsections 1 and 1 capital A. So let's start by looking at 82(1)(b), a secure tenancy, which is a tenancy for a term certain, but subject to termination by the landlord. It cannot be brought to an end except as mentioned in subsection 1A. So what does that mean? It means that a fixed term secure tenancy can't be brought to an end unless it's subject to termination by the landlord. The obvious first question then is, what does subject to termination by the landlord mean? In the High Court, it was held that a fixed term tenancy was subject to termination by the landlord only if it contained a forfeiture clause. And as Kelvin will come on to, Mrs. Justice Tipples held that this tenancy agreement did not contain a forfeiture clause. So at High Court level, councils learned that if they didn't have a traditional forfeiture clause in their flexible tenancy agreement, they couldn't recover possession until the fixed term expired. Now, in most cases, that means a maximum of 5 years, but 5 years with, say, an antisocial tenant might seem like rather a long time. On appeal, the Court of Appeal held that actually, subject to termination by the landlord in 82(1)(b) meant any lawful means by which a fixed term tenancy could be brought to an end as a matter of contract, overturning that part of the High Court's judgment. So what were we talking about in practice? Broadly, we were talking about forfeiture clauses and we were talking about break clauses. The consequence of the Court of Appeal's judgment was that councils learned that as a matter of principle, they did not need a forfeiture clause to bring a fixed term tenancy to an end before its expiry. And we'll come on in a moment to whether that actually helped local authorities in practice. In the Supreme Court, it was our appeal, it was Croydon's appeal. The tenant put in a respondent's notice on this point, and it asserted that the High Court judge was right and the Court of Appeal was wrong, that a fixed term tenancy was subject to termination by the landlord only if it contained a forfeiture clause. Its decision is at paragraph 44 on this issue of its judgment. And what Lord Briggs, on behalf of the Supreme Court, held was that a fixed term tenancy is subject to termination by the landlord within the meaning of section 82(1)(b) when a provision for early termination becomes exercisable. And that was the novelty. What does that mean? Well, for example, if you're talking about a forfeiture clause, it's exercisable when the tenant is in breach, and if it's a non-rent breach, a section 146 notice has been served. It will cease to be exercisable if there's a waiver of the breach. So the local authority had argued that a tenancy was subject to termination by the landlord merely because it contained a means by which possession could be recovered. And the introduction that Lord Briggs made was only in the event that the relevant term becomes exercisable as a matter of fact. How does that work in a break clause case? Well, it's exercisable when the qualification has arisen. So, for example, if you have a 2-year break clause, notice must be served on or after year 2. And the tenancy is subject to termination on or after year 2, depending on its precise wording, when it becomes exercisable. You'll remember that this was the respondent's notice point put in by the tenant, and she was wrong to suggest that the tenancy agreement contains a forfeiture clause. And put simply, it isn't necessary that a tenancy agreement contains a forfeiture clause in order that it be subject to termination by the landlord. But what did that mean to the ability to recover possession? That was what arose under the second issue, and this was the issue advanced by the council. Let's look at subsection 1A. This is what was described from the High Court up as the menu. The tenancy may be brought to an end by the landlord obtaining a possession order and executing it, obtaining a termination order and obtaining a demotion order. So the second issue before the Supreme Court was, by what means may a landlord recover possession of property let under a fixed term during the term? The first issue looked at the principle, how you open the door. The second issue looked at the practice, how do you actually get your remedy? In the High Court, it was held that any of the menu options, any of the routes to possession was available. So as long as you got past the door of section 82(1)(b), you could seek a possession order, seek a termination order, seek a demotion order. And the way that that's been summarized is that you needed a forfeiture clause, but you didn't need to use it. The consequence, practically, was that as long as you had a forfeiture clause, you were entitled to recover possession on the statutory grounds in the usual way. In the Court of Appeal, Lord Justice Arnold came to a different conclusion. The conclusion to which he came was that a fixed term tenancy subject to termination by the landlord could only be determined by the termination order route in section 82(3). So Mrs. Justice Tickle said any of the three options. Lord Justice Arnold said only one option. Put that another way, the Court of Appeal held that you didn't need a forfeiture clause in order to be subject to termination by the landlord within the meaning of 82(1)(b), but you did need a forfeiture clause in order to actually recover possession under section 82(1)(a)(b). And if that sounds confusing and complicated, it's because it was confusing and complicated, and certainly for Croydon's part, rather unsatisfactory. The way that's been summarized is that you didn't need a forfeiture clause, but you did need to use it, which is the exact opposite of what the High Court had said. As you might expect, the decision of the Supreme Court is rather more nuanced, and it's not the way that either party argued the case, although I'm bound to say it's much closer to the way that the local authority argued the case. The answer that Lord Briggs gives is that consistency is key, and this is where new ground was broken, particularly at paragraphs 59 and 60 of the judgment. What did Lord Briggs say? What he said was this: if you assert that your tenant is at fault, you must rely on a forfeiture clause. And Kelvin will come on to what that means. If you rely on a forfeiture clause, you must seek a section 82(3) termination order. Now, I just want to look back at the statute again. So 82(1)(b), you are a tenancy that is subject to termination by the landlord because you have a forfeiture clause. You can bring that tenancy to an end in a means mentioned in subsection 1a. Which means can you use? You can use B, obtaining an order under subsection 3, termination order. If instead you assert a right to possession based on the management grounds, like redevelopment, which do not require fault on the part of the tenant, you must rely on a break clause. And in those circumstances, you can seek a normal possession order. So how does that work, looking at the statute? Well, you are a secure tenancy for a term certain, and you are subject to termination by the landlord pursuant to a break clause. That tenancy can therefore be brought to an end as mentioned in subsection 1(a). Which part of 1(a)? A, obtaining and executing a possession order on statutory grounds. But what you can't do, what you cannot do, is seek a normal possession order where the tenant is at fault, no matter how you've worded your tenancy agreement. And if the tenancy agreement contains no right to recover possession before expiry of the fixed term, then there's no means by which it might be subject to termination by the landlord, and there's no right to recover possession. Now, that's possibly hardly surprising, because if you have a fixed term tenancy in which you haven't reserved to yourself the right to recover possession contractually, the statute doesn't offer you a right you didn't reserve to yourself. Let me summarize that and close. If you seek possession for fault, you have to rely on a forfeiture clause and you have to seek a termination order. If you seek possession not for fault, you have to rely on a break clause and you may seek a possession order. That is the ratio of the Supreme Court. I'll come back when we're looking at questions at the end, but in the meantime, I'll pass back to Kelvin to help with ground 2.
Thanks, Riccardo. I can't see myself. I'm hoping that I am visible, or certainly at least you can hear me. To an extent, I think it's fair to say that the Supreme Court's approach to Section 82, as Riccardo has just explained, was softened by a rather liberal approach to construction of the contractual question ground 2, whether anything in Croydon's standard terms of tenancy constituted a forfeiture clause. If we could just look at those terms again, please. I think it's slide 5. There we are. I ought to make it clear at the outset that Croydon did not purport to forfeit Miss Kalonga's tenancy. It sought possession on the statutory grounds, but Miss Kalonga had nonetheless raised the issue that her tenancy contained no such clause, and for reasons that Riccardo has explained, that was quite a critical issue, certainly before the judge, and to a lesser extent before the Court of Appeal. But the Supreme Court felt, nonetheless, that it was a sufficiently important point and a point of general application that it was right to deal with it, and deal with it they did. The clinching argument as to why none of the terms that we're looking at here on this slide constituted a forfeiture clause in the High Court and the Court of Appeal was because of this historic difference between a clause which, when triggered, brings the tenancy to an end there and then, forfeiture, classic forfeiture clause, and one which merely entitles the landlord to apply to a court for an order of possession, which is the effect of these clauses here. And although there was historical authority for the approach the lower courts took, it was one that ignored the realities. The realities being, of course, that for over half a century, landlords cannot take physical repossession against a tenant in lawful occupation, and they must go to court for a court order. And of course, also, we're dealing with a statutory scheme which provides that the only basis for getting possession is by making out the statutory grounds. So the Supreme Court, unlike the courts below, was prepared, I think, to look at the reality of the situation. The Supreme Court rejected the conclusions of the court below and found that all the terms that we're looking at here constituted forfeiture clauses. And the following points in particular emerge from the single judgment given by Lord Briggs, with which the other members of the court agreed. First, whether a particular clause is or is not a forfeiture clause is a question of substance and not form, paragraph 50. Secondly, a clause will be a forfeiture clause if A, when exercised, it operates to bring the tenancy to an earlier end than it would naturally terminate, and B, it is exercisable in the event of some default by the tenant. So that's the Clay's distinction that the Supreme Court has now, or the Clay's test that the Supreme Court has now endorsed. That's paragraph 52, Lord Briggs' judgment. Thirdly, in construing any clause, consideration must be given to the statutory scheme, and in particular to the fact that landlords can only lawfully enforce a forfeiture against a person lawfully occupying by proceedings in court, paragraph 57. And fourthly, a clause which entitles a landlord to apply for possession on those statutory grounds which are fault-based, and we've looked at those briefly, grounds 1, 2, and so forth, is likely to be a forfeiture clause. Whereas a clause which entitles a landlord to apply for possession on those statutory grounds which are not fault-based, such as the managerial and strategic grounds, is likely to be a break clause. That's paragraph 59, and that's really important. So you can have one clause, such as the one that's set out in bold here. We may also take eviction at any time if one or more of the grounds of possession set out in Schedule 2 of these conditions apply, pausing there, Schedule 2 replicate the statutory grounds. That provision constitutes a forfeiture clause if it's relied upon in relation to a fault-based ground, but it represents a break clause if it applies to a non-fault-based ground. And that is, we have to say, a workable and elegant solution to the problem. So drawing the threads together, first, it's necessary to consider whether the tenancy agreement contains any term which enables the landlord to take steps to bring the secure tenancy to an end before its natural expiry date of the term. That's the first question. Is there a condition, a term in this tenancy, which enables the landlord to take steps to bring the tenancy to an end before the end of the fixed term period? If it does, then on the face of it, the tenancy is subject to termination by the landlord if and when the conditions giving rise to that term arise. That's the first point. If there's no provision, such provision in the tenancy, then the tenancy is not subject to termination by the landlord in any terms, and unless the landlord can persuade the tenant to agree to a variation, the landlord is locked in for the full term. Secondly, if such provision is exercisable upon the tenant's default, then as Riccardo has explained, it's likely to be a forfeiture clause. This will invariably apply to the fault-based statutory grounds. So to proceed for possession, the landlord must first obtain a termination order through the section 82 subsection 3 route, and this will give the tenant the right to seek relief from forfeiture. Helpfully, if the termination order is made, the landlord can proceed straight away to apply for a possession of the follow-on statutory periodic tenancy. Thirdly, if such provision is exercised otherwise than upon the tenant's default, then it's likely to be a break clause. The landlord may accordingly proceed directly to claiming possession under 82(1) capital A little a on non-fault-based grounds. Now, the judgment does deal briefly with other grounds upon which, as a matter of property law, a landlord may bring a fixed-term tenancy to an end, such as breach of a condition precedent. And we feel that that opportunity might exist when the circumstances arise, and it might have something to do, we'll touch upon this in the Q&A session, in circumstances where a fixed term tenancy ceases to be secure. So there it is, an outline of the decision, important decision of the Supreme Court in Kalonga. It's provided out of, I may say, very difficult legislative background, a workable solution. So what we're going to do now is we're going to move on to the questions that we've had from delegates. We've had a number in advance. We're very grateful to those. I see that one or two more are popping up as we speak. And I'm going to run through the questions. We're not going to show them on the screen. They're fairly short and straightforward, but excellent questions nonetheless. And we'll do them as best we can. So I have a question from Peter Fabian from Brent Council, who asks, what can a landlord do if it hasn't served a forfeiture notice, but has served a notice seeking possession or notice to quit for non-occupation? Can they still serve a forfeiture notice? What happens if an issued claim, if a claim is issued, but there was no forfeiture notice served, but there is a clause in the tenancy? So I think, Riccardo, you're going to deal with that question.
I'm going to deal with it in two parts. There are a few principles to establish first. The first is you can't serve a notice to quit to determine a fixed term tenancy, because the function of a notice to quit is to determine a tenancy at the end of a period, which means it only works with a periodic tenancy. The second is, I presume the phrase forfeiture notice means a Section 146 notice within the meaning of the Law of Property Act 1925, which is a form of notice that you have to serve in respect of any non-rent breach of tenancy. And the third is, in the case of a fixed term tenancy, the landlord is to serve a notice seeking termination rather than a notice seeking possession. It's just a different schedule to the regulations prescribing the relevant form of notice. Right, those are the principles. Then the question, at any time at which the tenant doesn't occupy property as her only or principal home, she doesn't satisfy the tenant condition and therefore doesn't attract security of tenure, and therefore Section 82 doesn't apply. So in opening, Kelvin said that the provision that provides security of tenure is Section 82(1). But Section 82(1) only arises if the tenancy is a secure tenancy. If the tenant is not occupying the property as her only or principal home, is not a secure tenancy. It therefore needs to be determined pursuant to the contractual route. In those circumstances, you don't need to serve a notice seeking termination at all, because your right to possession is contractual. Now, this is a fixed term tenancy, so you need to terminate it either on the basis of breach of condition, if you can assert that failure to occupy the property as your only or principal home is a breach of condition, or by forfeiture, if you can assert that it's a breach of tenancy. You'd probably seek to do so on the basis of breach of condition, because relief from forfeiture doesn't then arise. And the second part of the question is, what happens if you've already issued a claim, but you didn't first serve a Section 146 notice? Well, if it's a non-rent breach, you have to serve a 146 notice, because that's what gives rise to your right to forfeit. If you rely on forfeiture, but didn't first serve a 146 notice, and you need to serve a 146 notice, and then either seek permission to amend your claim or bring a new claim.
Thanks,
Shall I
Riccardo.
go straight on to the second part of Fabian's question, Kelvin? I'll just look at question 2. The question is, in what order do notices have to be served? For example, first the 146 notice and then the notice to quit. Well, the answer, I've given half of it already. There's no notice to quit in respect to the fixed term tenancy. So if you're relying on forfeiture, you serve first your 146 notice and then your notice seeking termination. And the reason you do that is that, at least in part, or in most cases, the remedy will be capable of, excuse me, in most cases, the breach will be capable of remedy. And you have to give the tenant a reasonable opportunity to remedy her breach before you purport to recover possession. So you serve her the 146 notice, you say your breach is X, you can remedy it by doing Y. If it's not remedied, you serve your notice seeking termination. And then the final question Fabian asks is, do the section 146 notice and notice under the statutory scheme have to be served at the same time? I think I've answered that. 146 first, if it's a non-rent breach, notice seeking termination second.
Thanks, Riccardo. Now, moving on, Patricia Michael Forrester asks, in light of the Kalonga decision, should social landlords now be reviewing their fixed-term tenancies or simply ditch them? Yes and no. They should certainly be reviewing their fixed-term tenancies and asking themselves whether, in the light of the Kalonga judgment, those tenancies contain terms which make them, or potentially make them, subject to termination by the landlord, either as forfeiture clauses or as break clauses, as Lord Briggs has identified. And I think that that's critical. If the tenancies contain no such provision whereby the landlord can seek early termination, then the only course is to, and some local authorities have achieved this, but not many in my experience, is persuade their tenants to agree to a variation to write in the clause. But assuming that there is such a clause in the tenancy condition, then the local authority or the landlord really needs to look at its procedures, understand what those clauses do and how they should be operated, whether they, for example, would operate as a forfeiture provision, in which case the local authority needs to set out a procedure to be followed so that it can effectively forfeit should it wish to do so, and understands the pitfalls of forfeiture, not least waiver of breach, or indeed to treat them as break clauses. So there are sort of management reasons for looking closely at the terms of tenancy agreements and deciding how to proceed. In terms of ditching them, we don't think so. There's a lot to be said for a fixed term tenancy. As I said at the outset, very few local landlords bother with fixed term tenancies outside the flexible tenancy regime. But of course, the flexible tenancy does give the landlord the mandatory ground for possession at the end of the term, and that may be seen as a valuable right. The concern when we're at the High Court and Court of Appeal level is that the local authority or the landlord may have fixed itself with an obligation that it couldn't get out of, whatever the circumstances. But we, as we've sought to explain, that's no longer the position. So the next question we've had was from Kenneth Cohen from London Borough of Harrow, who I think Riccardo has probably covered this, but it invites us to consider the situation where the fixed term tenancy has ceased to be secure, because the example that Kenneth gives us is that the tenant has been convicted of murder and sentenced to prison for 30 years, so that in those circumstances the tenant would no longer continue to satisfy the tenant condition section 81 and the tenancy would cease to be secure. But as Riccardo has explained, it's a contractual tenancy, and in those circumstances the question is, does the landlord have the contractual right to bring the tenancy to an end? Section 82 simply doesn't come into it because the tenancy isn't secure. And the opening words of section 82 make it clear that the section only applies to secure tenancies. So in those circumstances, the question would be, is there a contractual right to terminate the tenancy. Three possibilities arise. There might be a right to forfeiture in those circumstances. There might be a break clause in those circumstances, or it might be one of those cases where it's a breach of a condition precedent, which would entitle any party to a contract to bring an end to the arrangement prematurely upon breach. So as that, we move on now, I think, to a question from Amanda Kendall from Crawley Borough Council. And she would like to know about the ability to accept rent without prejudice in the case of a secure, flexible tenancy with a local authority. If we decide to keep flexible tenancies in the light of the Kalonga judgment, the ability to accept rent without prejudice may be a determining factor. Riccardo.
Amanda, the situation is this. The tenant breaches the tenancy, putting the landlord to its election. Either the landlord treats the tenancy as being at an end by forfeiting, or the landlord waives the breach. How do you waive the breach? By acknowledging the continued existence of the tenancy. How do you do that? Well, the most obvious example is that you demand or accept rent. So this question is about accepting rent on a without prejudice basis. It's a complicated question on which you'll want to seek proper advice, but in brief, there's authority for the proposition that you can inform your tenant that you'll be accepting any payments that are received as contributions to the use and occupation account without waiving the right to forfeit. It's effectively a prepayment of damages for continuing to use the property when the tenancies come to an end. But as I say, that's a very brief and simple way of saying something that's actually rather more complicated. The next question we've got is from Baljet at HB Public Law, who asks for some clarity on what sort of tenancy clauses are sufficient to allow a local authority to seek possession of a fixed term tenancy, regardless of whether possession is due to default or not. From the Supreme Court judgment, it appears to be enough to say that the landlord can recover possession at any time on any of the statutory grounds. It appears to be enough to say that. I can't stress enough that this is an important point on which, if you seek to rely or want to take proper advice, that sort of grounds, that sort of clause that I've outlined will be a forfeiture clause in relation to the fault grounds 1 to 8, and it will be a break clause in relation to the management grounds in 9 to 16. I mean, that is an oversimplification, but the effect of the judgment is that if it allows the tenancy to be determined early for breach, however it is set out, a clause will be a forfeiture clause. And if it allows the tenancy to be determined early without breach, however set out, the clause will be a break clause, while the tenancy is a secure tenancy. Sorry, the next one's mine as well. It's asked by two of our participants, Emily from Hyde, hi Emily, and Marion from the Guinness Partnership. And the question in brief is, what reference can we make to tenancies granted by housing associations? To the extent that the housing association satisfied the landlord condition in the 1985 Act, the provision is identical. Housing associations who are landlords within the meaning of the Housing Act 1985 are to be treated for these purposes as an identical manner to local authorities. To the extent that the housing association doesn't satisfy the landlord condition, the lead case is Artesian and Beck, which broadly says that it's not necessary to bring a forfeiture claim to determine a fixed term assured tenancy because of section 45(4) of the 85 Act. So the provision is just completely different. And Kelvin, I think back to you.
Thanks, Riccardo. Now, Rebecca Brady asks, practically, how do you think a local authority will have to terminate a flexible fixed-term tenancy for ASB in the light of the decision? Does this mean serving a Section 146 notice and a NOSP together and issuing proceedings relying on both simultaneously? Or will they have to commence forfeiture proceedings first and terminate the fixed term and then serve a NOSP to bring the arising periodic tenancy to an end? Well, the crisp answer is the Court of Appeal dealt with this, and you could serve both 146 and the NOS simultaneously, and then on the same occasion ask the court to firstly terminate the tenancy, the effect of which, if granted, is to convert the fixed term into a statutory periodic, and then immediately to make a possession order. But there's also another approach to this, and I think it's one that has some historic basis in the 1980 Housing Act, in that in a case where the local authority thinks that the tenants should be brought to court to answer for some breach, but it's not a case where the court would make an outright possession order, or the local authority doesn't want to go that far. On a fixed term tenancy, the local authority can apply for a termination order and leave it at that point, a sort of warning shot across the bows. Now, this has a sort of crossover approach with demoted tenancies, but historically, I think that was a basis upon which you could do. So in the ASB case, the local authority could say, right, well, first off, we're going to serve a 146 notice, take it to court and get a termination order, but we're going to tell the court we're not going to take it any further, provided you comply. So it can be done in a staged way. So I'm just looking at the time. Riccardo, have you got time for one quick question, or are we going to end it there? I think probably.
We've got a few more questions, all of which are interesting and none of which we can answer particularly quickly.
2 minutes.
Amita, I'll answer your question in the chat box. The local authority relied on the clauses that we put up in our slides, and the Supreme Court didn't say these ones are forfeiture clauses and these ones are break clauses. And on my analysis, the reason it didn't do that is that depending on the ground that was relied on, each of the clauses was capable of being a forfeiture clause and or a break clause. So if the local authority was recovering possession because of rent arrears, then it was a forfeiture clause. And if the local authority was recovering possession because of ground 10, then it was capable of being a break clause. So I'm afraid that I can't say read Croydon's tenancy agreement and look at clauses 1, 2, and 3, and that will tell you what a forfeiture clause looks like, and then look at clauses 4, 5, and 6, and that will tell you what a break clause looks like, because that's not how the analysis came through in the judgment of Lord Briggs. And Fabian, I'll answer your question as well, because it's very short. The 1987 order prescribes the forms of notice that apply to termination and possession orders following on from secure tenancies. A notice seeking possession is just one of the two forms. The notice seeking termination is another of the two forms, and it's the one that you have to use if you're seeking possession and or termination in respect of a fixed term tenancy. So go to those, I think it's an order, it might be regulations, go to that order and look at the schedules, and that will tell you the answer to your question. I think, and I'm afraid that's all we've got time for, but that doesn't mean that the few questions that are left over, and Astrid, I'm looking at yours in the Q&A panel, aren't questions that we could answer, but do feel free to, maybe I won't offer for Kelvin, but do feel free to send me an email if you'd like me to answer any of those questions, and I'm sure Kelvin will extend the same position. Of
course, thank you very much indeed. Well, it only remains for me to thank delegates for the attendance today, and to wish you all well, and hopefully we'll be able to see many, if not most of you, in person at the Cornerstone Barristers Housing Day in the autumn. So please look out on the website for that. So thank you again for your attendance. Bye-bye.